Truth often sacrificed for the sake of stability and peace. When stability becomes a habit, maturity and clarity follows. Peace in society depends upon the peace in family.
Rapid changes in life over the last 40 decades have led to substantial alterations in family law policies. Specifically, most states now endorse joint custody arrangements for divorcing families. The study reveals that in all regions of the world, the family itself is undergoing major changes.
Today, we are all gathered here on this virtual platform for the closing ceremony of the 11th International Seminar on Family Laws, Changing Perspectives, Contemporary Challenges and Solutions, organized by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research, KELSER.
Kerala Law Academy Law College, which was unfolded in the field of legal education in 1966 by the legal luminary late Dr.N.Narayanan, is a seat of excellence in legal studies, research, consultancy, and pioneering law reforms.
A delightful evening to one and all present here on this virtual dais. Today, on this auspicious occasion, we are immensely grateful for the presence of esteemed dignitaries.
On the eve of this valedictory session, before going ahead, let's spend a minute in silence to cherish the memory of our beloved founder of Kerala Law Academy Law College, late Dr.N.Narayanan, who is our epitome and a symbol of legacy.
Thank you all. Now, let's watch a video to know more about mediation and its major tips and tricks by Bhuvaneshwar sir.
Mediation has proven to be a valuable resource when it comes in the matter of resolving a family dispute. It also resolves this dispute faster than approaching in any court. Peace and harmony among the family members are very important in any family relationship. The mediation process helps in serving this purpose and helps to solve these differences through discussions. Now we have Advocate Bhuvanendan sir to tell us some tips and tricks on improving the efficiency of mediation in family law disputes.
Mediation, you all know, it is an area process in that a neutral third party, a mediator, settling the dispute amicably with the confidentiality and with the self-determination. The parties are ultimately deciding the matter because totally it is with them. Self-determination is the main in mediation. Totally confidential. So a neutral third party is making the ambience to the parties to settle the dispute by themselves. He's not suggesting, he's not judging, he's not giving any opinion in that. Only he is making the parties or assisting the party or facilitating the parties to come to a settlement. That is the beautiful process because both the parties are winning in that there is no enmity, there is no revenge, both are winning. Finally both are happy, we can keep peace and harmony in the society. That's the best thing. The mediation is one of the best process as far as the family disputes are concerned. Why? Because in family disputes, the emotions are involved. The main aspect is emotion. A mediator who is going to settle or going to mediate a family dispute, because there are special aspects like emotion, custom, practice, then motivation, sentiments. Many aspects are involved in that. You have to address all these elements. Then only you can come to an amicable settlement with utmost satisfaction. Moreover, in family or in marriage, many laws are involved, many customary practices involved, many beliefs are there, the attitudes of the parties. Moreover, the rights and duties, as per certain social expectations. These are the aspects are involved in marriage and family aspects. So these are to be taken into consideration while deciding, while mediating a family dispute. That's why normally it is said that before filing the reply, once the reply is filed, many allegations may come in the reply. So thereby the gap between the parties may increase. To reduce the gap, it is better before filing the reply. Now recently in May there is an amendment made in the Family Court Rules 1989. the rules which says that even before sending the summons, before giving summons to the parties, the judge has to go through the petition or application, and if he finds that there is an element in settlement, it has to be a notice to be given to the parties to come before the court, and it may be sent for mediation. Why the dispute is taking place in the family? The first and foremost thing is lack of communication, maybe misunderstanding, or the proper opening up of minds are not taking place. In mediation, what we can do, we are giving chance to the parties to open up their minds, better communication. Because in family, the lack of communication is the main thing, and misunderstanding is the main thing in family dispute actually. So joint sitting and many private sitting also can be conducted. Private sitting, no. So much of private sitting is required because there is no one to hear their grievances. So first of all, the mediator has to hear them. Active listening is most important. Then the communication technique, the proper communication between the parties, the chance to be given proper communication between the parties. After that, give them sufficient time to vent out their feelings and try to find out the underlying interest in that. Then only we can easily settle the dispute. That's it. Normally I said that, not like other dispute, family dispute, the mediator has to give much care to the emotional aspects also. Not only the legal aspects and the material aspect like maintenance and compensation. The emotional aspect is so much important. So that to be kept in the mind of the mediator while dealing with the matrimonial issues. Much care to be given, much time to be given, much attention to be given. Then only we can give a better result, better settlement to the parties.
Thank you. The role of leadership is to transform the complex situation into small pieces and prioritize them. Today, we are extremely privileged with the presence of Advocate Nagarash Narayan Sir, Director, Kerala Law Academy Law College, Special Government Leader, High Court of Kerala. It's my great pleasure and honor to welcome Advocate Nagarash Narayan Sir to deliver the welcome address. Sir, please.
Am I audible?
Yes,
Can
sir,
you
you're
hear me?
audible. Yes, sir.
Respected dignitaries on the virtual dais and dear friends, students, brothers and sisters. Now we have come to the valedictory function of the International Seminar on Family Law, Changing Perspectives, Contemporary Challenges and Solution. And I would say that it is a moment of extraordinary pride and honor to welcome all of you who have gathered here to take part in the valedictory function of this international seminar. The seminar has explored different aspects of modern family law as it plays a crucial role in our present day society. The purpose of the seminar was to discuss the changing perspectives, changing role in family laws. The seminar also discussed various challenges faced by different family laws and comparative positions available in the all over the world and the solutions to overcome these challenges. We have addressed on how the family law can be redefined, reimagined, not to merely accommodate the diversity, but also to fulfill the needs, interests, and also to secure the rights of individuals and communities. However, we have provided a premier interdisciplinary platform for researchers, practitioners, and educators to discuss the most recent innovations, trends, and concerns, as well as the practical challenges encountered and solutions adopted. And it has come out with so many research papers. I hope I am fully optimistic that a very good research outcome would be there with a very good publication of the research papers, which would definitely have an impact on law. Now, let me proceed on to my duty of welcoming the dignitaries on the virtual dais. First, as the president of today's function, we have Dr. Vismi Gopalakrishnan, who is the professor and head of the School of Indian Legal Thought, Mahatma Gandhi University, Kottayam. Now, Madam, the association of Madam with our institution is so very intimate, so sincere and genuine that she is one among the family, our family member, as a part of our Law Academy family. Madam had held so many important positions. She was the former director of B.R. Ambedkar Chair, Center for Human Rights and Social Justice of the University of Kerala, and the assistant director for Center for Global Academics of the University of Kerala. And also, she is the coordinator of the patent cell of the Department of Law of the University of Kerala. She is also member of Faculty of Law, University of Kerala, member of Postgraduate Board of Studies, University of Kerala, associate editor of Kerala University Journal of Legal Studies, and has produced several PhDs, several scholars of eminence, and apart from being such a distinguished and recognized supervising teacher of research in law at the University of Kerala. I'm extremely happy to have such a very important person to this function. Welcome, madam. Welcome to this valedictory function. Next, we have the distinguished personality is Sri Nigusa, Professor Mr. Nigusa Hafiza, who is Associate Professor of Hawassa University, School of Law Hawassa in Ethiopia, who is now taking part in this function from Ethiopia. I hope so. He is personally in Ethiopia. He is an expert in policy preparation and implementation, and especially with regard to this family law changing perspectives and contemporary challenges and solutions. He is an expert in policy preparation for such issues and for implementation of the same. It is my great pleasure to welcome you, sir, Mr. Nigusa Hafiza. Welcome, sir, to this function. Welcome to this function. Next, we have the gracious presence of Professor Dr. Y.F. Jayakumar, who is Dean of the Research Council Maharashtra of the National Law University, Aurangabad. He has a teaching career spanning over more than 30 years. He is an eminent personality with authoritative knowledge in the field of law. Professor Y.F. Jayakumar, sir, is a subject expert in family law, constitutional law, alternate dispute resolution, and law of evidence. He is the coordinator for production of e-content program in law based on UGC. Apart from this, Professor Y.F. Jayakumar has an association with national law schools, universities, and other academic bodies in India as subject expert as UGC nominee. As on today, he has produced more than 15 PhDs, 15 doctorates in various universities across India. And in fact, another distinguished personality among us in the virtual dais. Sir, it's a pleasure to welcome you, sir. On behalf of all those present here and Law Academy, I extend a warm welcome to you, sir. Welcome, sir. Yes, we have Professor K. Anil Kumar, sir, who is a master in training and a master as far as coordinating all these activities, who is a torchlight for us, a leading lamp for us. He is presently the director of Students and Faculty Affairs of Kerala Law Academy, and I'm extremely happy that sir is also here for this function. I welcome Professor K. Anil Kumar, sir, to this function. Next, our principal, Sri K. Harindran, sir. He is here. He is also very actively associated with the organization of this program. On behalf of all those present, I extend to Professor K. Harindran, sir, the principal of our institution, a very warm welcome to this function. Next, I welcome Advocate Arya Sunil Paul, Assistant Professor of Kerala Law Academy, to this function, who is the live wire, the chief organizer of this International Conference. Welcome, Adia, to this function. Then we have senior professors G.L. Kumar and also Associate Professor Ajida and all other teachers. I'm not mentioning all the names. I extend a warm welcome to all the teachers, faculty members of Kerala Law Academy and other institutions. And finally, I extend a warm welcome to all the participants, students, conveners, and non-teaching staff who are present here in this virtual platform for this conference. Thank you all. Welcome all. Thank you. Thank you.
Thank you, sir. Thank you.
Thank you so much, sir, for your warm welcome. I take this opportunity to welcome you too in this event, sir. Today, we are extremely delighted with the presence of Dr. Bismi Gopalakrishnan Ma'am, Professor and Head, School of Indian Legal Thought, MG University, Kottayam. It's my great pleasure to welcome Bismi Gopalakrishnan Ma'am for the presidential address. Ma'am, please.
Thank you. Thank you, Namita. I'm audible, right? You can hear me? Okay.
Yes.
Advocate Nagaraj Narayan sir, Director, Kerala Law Academy. Mr. Ligusi Efisa, Associate Professor, School of Law, Hafasa. Most respected Professor Dr. Y.F. Jayakumar sir, Osmania University. Arya Sunal Paul. Professor Harendran K, Principal, Law Academy, Law College. Professor Anil Kumar K, Professor Anil Kumar G, Ajita Ma'am, Dr. Dakshina Saraswati, the research scholars of Kerala Law Academy, the PG and UG students of Kerala Law Academy, and all the esteemed family members of Kerala Law Academy, esteemed participants of this 11th International Seminar hosted by Kerala Law Academy. Actually, when you're just thinking about the family law and the changing perspectives of family law, I have always felt that there was always a need to break the silence. There was actually an ominous silence regarding family law. And whether family law should recognize the link between law and the needs of the rapidly changing society is an issue that was not systematically addressed by our legal institutions. And very often we can find that family law is often considered synonymous with personal laws. Now, this trend of gluing family law with personal laws, we always maintain a silence regarding the whole concept of just family law. Now, a glance at the brochure of this international seminar, we can understand that the seminar has generated a discourse on just family law. It is sown, I can understand that if you just go through the different sessions, we can understand that it has sown the seeds on the minds of the esteemed participants to move beyond the impasse of debates about religion versus state, about majority versus minority views. Now, it is a fact that the concept of family, the concept of law, the concept of justice, these are all contested ideas. Now when we rethink family law from the just family law perspective, we can find that we are trying to enable people to live together in relations with affection. We're also trying to provide a framework of rules for forming and dissolving unions. We're also thinking how to eventually or evenly distribute the cost of entering into relations. So if family law is examined in the light of all these aspirations of a just family law, it is readily understood that the family law needs to be relearned and rediscussed. And we need to rethink about whether family law need to be contextualized or conceptualized only as a dispute resolution mechanism for parties to a marriage, or whether it needs to cover much more. For example, subjects like employment conditions for parents, availability of adequate healthcare for mothers, violence in intimate relations. And again, actually, family law has to be very diverse. It has to radiate diversity. And it is also a context sensitive also. So when law employs open textual languages, it has to have a very broad perspective also. So it is the right time to lift the familial veil, to undertake a close scrutiny of what is happening around the society, what changes are happening in the society. The scrutiny of status, of rights and disabilities of some of the so-called subordinate members in the family, be it the divorced wife or the adopted child or the members of the different sexual orientations. So this international seminar, we have it is evident that it has started a very adventurous exploratory academic journey of inquiring into the how to empower those who are subordinated, to question the pathologies of power within the family, and to propagate the remedy for the inequities that has existed in the so-called the silences. So let us all together break the silence and move ahead with the ray of hope that is being triggered by this international 11th international seminar. Thank you.
I extend my heartfelt thanks to you, ma'am, for your valuable words. It is certain in any case that ignorance allied with power is the most ferocious enemy justice can have. Today, we are immensely grateful for the presence of the eminent personality, Mr. Nigose Afesa Ayesh, Assistant Professor, School of Law, Havasa, Ethiopia, who is an expert in policy preparation and implementation. It's my great honor to welcome our dignified chief guest to address the valedictory session. Sir, please.
Is that my turn?
Yes, sir, it's your turn.
Okay. Sorry for not voting me. I think I faced some kind of technical problem in that respect. I think you can hear me loudly.
Yes, sir, you're audible.
Okay. Thank you, your respected sir and madam. My presentation basically focused on changing perspective using Ethiopian context as a case study. So taking that into account, let me say a few things about family law in general. And I'm going to make a overview about what are the changing perspective worldwide and in Ethiopia context. The first thing I have been seeing that the definition of marriage in general. Shall we define marriage in the usual form as a union of a man and a woman, or shall we change it? There are persons who argues that marriage should be defined in the same way as it was. Of course, there are persons who define marriage as a union of individuals. Any law, family law of any country, expected to contain detailed substantive and procedural rules that regulate the various aspects of marital relationship and cohabitation. Of course, most of the family law regulate basically a substantial part of the family law regulate marital relationship between two persons, but still variation exists among the state in terms of regulating some family matters. Specifically, there is still a serious debate about for the recognition and and recognition of same-sex marriage? And at the same time, shall we consider marriage as an institution or a contract? And at the same time, shall you countries supposed to recognize void or voidable marriage? There are changing perspective on this respect, and I will raise some of the points. In Ethiopia, the Ethiopia Family Code, which is applicable in different regions, contain different kind of substantive and procedural laws. But I can tell you that the family law is basically changed with the changing attitude of the society, and to some extent, the family law itself tries to shape the attitude of individuals. Having said this, let me start with defining and redefining marriage. And the notion of marriage as a union of a man and a woman has been with us for a millennia, but this definition of marriage is contested by many, and there is still a changing perspective whether the definition of marriage should include same-sex marriage or should be confined for a person who have a different sex. One of the reasons why we don't want to recognize same-sex marriage in Ethiopia context with the assumption that recognizing same-sex marriage basically jeopardizes one of the important purposes of marriage, which is procreation. But although in the other way around, there are also countries that argue, the authors and countries that argue that same-sex marriage should be recognized as civil partnership, with the assumption that marriage doesn't necessarily confine to affection part. It also includes the interest and the freedom of others. That is the assumption. In spite of this, a growing number of countries, in spite of the fact that same-sex marriage jeopardize the very purpose of marriage, that is, like I mentioned before, procreation, but there are a large number of countries that recognize same-sex marriage. In Ethiopia context, it is not only same-sex marriage is unrecognized, but we have also a saving clause that says if there is a marriage celebrated abroad, and that marriage will not be recognized as valid unless it's complied with the policy, the moral requirement of the society. So at any rate, marriage celebrated between sex marriage, although it can be viewed from human rights perspective, but the Ethiopian Family Code doesn't give any kind of protection for same-sex marriage. Of course, there are persons who argue that this should be changed, and of course we know that there is changing perspective worldwide on this point, but still the Ethiopian government and the Ethiopian society, because of cultural reason and religious cause, it doesn't give any kind of recognition. It categorically deprives legal recognition for any kind of relationship between person who have the same kind of sex. The other point I can see a bit or change perspective is, shall we consider marriage as a contract or an institution? Of course, marriage is considered as an institution because it should be governed by legal, moral, and community expectations. The assumption is that. And the marriage should not be considered as a union of a relationship between two people. It also involves the society and the state. This is one perspective. This perspective assumes that marriage should be considered as a status but not a contract. On the other hand, there are persons who argues that from the libertarian perspective, that give much emphasis on individual freedom. I think you know that. So a marriage should be considered as a contract, not a status, and it should be left for the choice of person who are in the relationship. And the assumption for such kind of articulation is that in any case, the business of the state is to regulate basic requirement for contract, and the rest has to be left for the parties. The assumption is that. But on the other hand, if we rely or choose either of the two, it will not be sound at any rate. And the compromise position now is that marriage should be considered as a status, but we have some elements of contract that should be left for the parties themselves. And in Ethiopia context, marriage is considered as not a contract, it is considered as a status, but it gives some kind of room for contract party to deal some of the matter by themselves. So I can say that the Ethiopia revised family code chooses the compromise position without giving too much regard for either the status, marriage as a status, and a contract. The other controversial situation that is specifically in Ethiopia is the issue of recognition of void and voidable marriage. I think every country laws have some kind of such kind of concept. In case of void contract, as you all know, that it is void ab initio. The principle is void ab initio. It was considered as invalid from the very beginning for the mere non-fulfillment of mandatory formality requirement, you know that. But there are also countries that gives voidable, that recognize voidable marriage, which means the marriage can be corrected. There is a chance a marriage to be rectified, but it contains some kind of defect. The problem in both sides is that in case of voidable marriage, we should not apply the void ab initio principle strictly, because there might be children that comes out of the void marriage. In that case, the concept of strict applicability of void ab initio may not be applicable. In case of voidable marriage, it still have its own problematic part. Take, for instance, you can see that a person may have a bigamous marriage with two women. In that case, the problem lies is that how if the marriage is dissolved because of its voidability, what kind of consequence it will have on the property right of the divorced spouse, or the spouse whose marriage is dissolved for cause of it contains some kind of defect. In Ethiopia, the Ethiopia family code contains no direct and detailed provision in this regard. Most of the courts, especially the Supreme Court of the country, divide the property of the divorced bigamous spouse like 1/3 for the three, which is also doesn't give much sound. This is the major problem that we need to consider whether a voidable marriage or a void marriage should be recognized in one country, and that is very important. Having said, as a changing perspective of all this, I will move directly with the contemporary issue under Ethiopian family code. Do you hear me? Hello?
Yes, sir, we are hearing you.
Yeah. Now I'm moving to use my time. I'm moving to see some of the contemporary challenge that we have been facing. The first thing I want to share for you is that the forms of conclusion of marriage. A marriage is supposed to be concluded in either of the three forms, or I can say that many states recognize multiple forms of marriage. The first one is customary, the other one is religious, and the third one is civil marriage. But the issue is to whom these forms of marriage is applicable. To make in a question for, can a divorced spouse supposed to follow this customary religious and civil marriage requirement to remarry again? The Ethiopian law seems clear on the plain and direct in this perspective. It seems that anyone supposed to conclude his or her marriage in either of the three forms. But a question arises: shall we use this multiple form of marriage for the person who are going to the marriage for the first time, or does this multiple form of marriage applicable for a spouse who are divorced and wants to live together again? Although many scholars in Ethiopia contest this part, the issue in one case the issue appears before the Supreme Court, and the Supreme Court gave us breakthrough the interpretation. It says that a divorced spouse, if they have a plan to live together, they are not supposed to follow any of the multiple the forms of marriage. They can their simple cohabitation can be considered as marriage. This, of course, negates the principle of cohabitation in general. I think you know that in case of cohabitation, it's all about living together without marrying each other. But this interpretation says that a divorced spouse, if they want to reunion again, they are not supposed to marry either in the customary, religious, or civil marriage. The former marriage will be reinstated and their status will be reinstated automatically. I think this may be a new for many of you. Other thing I want to share is the issue of fault and non-fault-based divorce. On this issue, I think in case of fault-based divorce, the spouse is supposed to show ground of divorce and prove that to the satisfaction of the court. In case of non-fault-based divorce, I think you are aware that spouses are not supposed to mention a single reason for the divorce, and it is an easy process. But the issue is that what kind of implication it will have on the divorce rate. I think in India, I think you all are familiar that there is, I guess if I'm not mistaken, fault-based divorce that is recognized, and the party are supposed to show that there is a situation where the marriage is in principle break irreversibly. But in Ethiopia context and in many Western countries, the family code recognizes fault-based divorce, and it has negative consequences in Ethiopia context aspect. In Ethiopian context, the Ethiopia family code is, I can say, liberal, modern, and progressive in many respects. Without taking the notes that I mentioned before regarding the recognition of sex marriage. But in here as well, the Ethiopia family code is more liberal in terms of content. It gives the party, the spouse, the freedom to dissolve their relationship at any time without mentioning any reason. And after the recognition of fault-based divorce, the divorce rate in Ethiopia goes high. So many tries to challenge and to pressurize the government to reconsider this policy. This is the non-fault-based divorce policy that we have today. And the record in the court even shows some kind of increasing. So the reason for this increase is assumed by many is that the recognition of non-fault-based divorce. So there is a pressure to change this to a fault-based divorce that India has. The other point that I want to share with you is that the difference between marriage and irregular union and what kind of effect it will have on property division. I think in marriage, the legal effects of property and personal effect commences automatically, but in regular union, it depends on the country. Its legal effect may commence after 2 years or more. In Ethiopia context, there is a different perspective here. The Ethiopia family code recognizes regular union, I mean cohabitation without marriage. Cohabitation without marriage is recognized in Ethiopia. The party is supposed to show that their behavior is analogous with that of a married couple, and they have to represent themselves to a third party. If these two components fulfill, their relationship considered as a cohabitation and a legal protection is given. But the problem lies that this recognition will not have effect until their relationship lasted for 3 years, a minimum of 3 years. If the cohabitant dissolves their relationship below 3 years, it will not have any kind of consequence on the property right of the spouse. The court will not entertain. The good thing is that if the relationship lasts more than 3 years, the law wants to give some kind of legal backup for such kind of relationship, and the property right of the cohabitant spouse, if they are dissolve their relationship after 3 years, they will treat their marital property right will be treated in the same way as we treat for the marriage. So there are legal provisions that regulate the financial consequence of relationship of persons who are living in a cohabitation. In most of family laws in other countries, the financial consequence of a cohabitant is regulated by general property law, but in Ethiopia it is governed by the revised family code, and it could be a lesson for others. The other point is the issue of divorce and alimony. Alimony is very known concept in most family code, where the claim for alimony is raised in the event of divorce, or I can say it is associated with divorce. But in Ethiopia, the issue of alimony is not recognized. The spouse who have been within a marriage for more than 10 or more years will not entitle any kind of alimony if the marriage is dissolved because of a number of reasons. And this needs some kind of policy suggestion. With the current reality, especially women who abandon their job for the interest of the household may not get the expected economic benefit of their devotion for the marriage. In most jurisdictions, it is known that if the spouse have marital relationship for long, and if their relationship is dissolved because of a number of reasons, the spouse will entitle some kind of alimony. This is the norm in many country practice, but there is no such kind of recognition in Ethiopia. This because of these women, specifically women, divorced women suffer a lot, and there is injustice for not recognizing alimony under Ethiopia. And previously, Madam also noted that family law should be seen in terms of justice. If you see the non-recognition of alimony in any family code, it is also can be regarded as an injustice for the interest of the spouse who devoted much effort and energy for the sustainability of the family. Other problem that we have been facing is concerning child custody. Well, child custody is recognized in Ethiopia Family Code, but the principle in case of marital relationship is dissolved for a number of reasons. The interest of the child should be taken into account, you know this, and how the interest of the child will be treated based on the principle of best interest of the child. But the issue is that how courts are applying the standard of best interest of the child. Of course, it is clear that the best interest of the child tells us whose interest is emphasized and prioritized in any decision. So the interest of the child should be emphasized and prioritized, but it is not clear as the text it is. So it may need some kind of detailed points that the court will consider in deciding that. So the court may take the risk-benefit assessment focusing on the child sorry, but there is still a problem in the decision of the court, and which means this principle is very difficult to apply as it is. So the court needs some kind of guidance, legislative guidance. So a detailed law should be there. And even in the presence of basic interest of the child in Ethiopia, courts usually give child custody for the mother if the age of the child is below 5. This is the trend, but this is not the concept of best interest of the child. Always, the interest of the child should be taken into account, the position and the condition and the economic income of the parent. But the practice in Ethiopia a little bit is very difficult. Other point that I want to share with you is the role of court in family dispute. It's true that family courts regularly decide on range of family issue that include divorce, alimony, division of matrimonial property, child custody, blah blah things. But in all of the decision, much discretion is left for the court in most of the issue. And the role of the court has to be constrained in some way by having a detailed law. In many legal systems, take for instance, there is a detailed law that governs ceremony. There is a separate law that regulates child custody, blah blah things. But in Ethiopia, there is. Hello, madam. Yeah.
Sir?
Yeah, do you hear me?
Yes, sir, we can hear you.
Okay. So these are the problems that I have seen in Ethiopia context. That solution I can tell you, I think I take too much time. So let me wind up in this way. There are some problems that I mentioned earlier, and some of them need some kind of legislative guidance, and some also need some kind of enactment. So this is the way how we handle. Thank you so much for your attention.
I extend my heartfelt thanks to you, sir, for your words of wisdom. And we are extremely honored and privileged to have you on board with us.
Okay, thanks.
Thank you. If you don't maintain justice, justice will not maintain us. Now we have Professor Dr. Y.F. Jayakumar Sir, Dean, Research Council, Maharashtra National Law University, Aurangabad with us. He has a teaching career spanning over 30 years. He is an eminent personality with authoritative knowledge in the field of law. I welcome Professor Dr. Y.F. Jayakumar Sir for the keynote address. Sir, please.
Good afternoon. Am I audible to you?
Yes, sir. Good afternoon, sir. You're audible.
Visible, both the things.
Yes, sir. You're visible too.
Thank you, Professor Bismi, the chairperson of today's valedictory session. Mr. Nagaraj, the director, Kerala Law Academy. Mr. Afisha, Havas University. My esteemed resource persons, participants, ladies and gentlemen. At the outset, I congratulate and compliment the Kerala Law Academy for taking an initiative to organize an international conference on family law and contemporary changes and also solutions. Of course, the topic is socially and legally relevant in view of the structural, functional, and normative changes in the field of family law. Because of or due to various factors like modernization, westernization, liberalization, and globalization. In this context, I thank the organizers for giving me an opportunity to make a brief presentation in this valedictory session. Friends, family being a basic unit of the society, and its members enjoy very number of privileges, immunities, benefits, and rights. At the same time, they also face a number of socio-legal problems that naturally arise out of various facets, like sometimes Sagotra marriages, sometimes Binagotra marriages, intercaste marriages, interreligious marriages, interdenominational marriages we have, and we have NRI marriages, and online marriage agreements are there, live-in relationship, same-sex marriage, and love marriages, and de facto and common law marriages. So from all these institutions, marriages are common. Don't be under the impression only from arranged marriages problems are there. We have problems from love marriages are there, de facto and common law marriages. The recent empirical study reveals that violence at home, like assaults, physical assaults, cruelty, both physical and mental cruelty, sexual abuse, and kidnapping, abduction, coercion, and verbal abuse, destruction of spousal property, spousal sexual violence, and marital rape, dowry-related issues, etc., have tremendous negative impact on matrimonial relationship. So this cannot be disputed. There are family issues identified generally in our textbooks: divorce, dissolution of marriage, and dowry-related issues, domestic violence, child marriages, custody and guardianship issues, NRI jurisdictions, juvenile justice care and protection aspects, assisted reproductive technology, surrogacy, and so on. I have seen some of these issues in your flyer. So that is a brochure, or what we call seminar flyer. And I cannot speak in all these aspects because the organizers are given time only 15 minutes. Yes. So that is the area is very vast jurisdiction, but I cannot finish it within 15 minutes. That is why, for the purpose of my presentation, I have chosen only 3 areas which are very, very important according to me. So in the family law is concerned, though they are what we call settled, some areas are settled areas, but still the importance of those areas are very necessary. Therefore, let me speak 15 minutes only on 3 important facets. One is the uniform civil codes, and the second one is the surrogacy, and the third one is family dispute resolution mechanisms in India. So the first one is uniform civil codes. The most controversial area and complicated area in the classroom, particularly family law teacher encounters, is the uniform civil codes. So there are 2 schools of thoughts. So that is how to judge it. At present in India, my dear friends, we have family laws that is called LAWS, not LOSS. Don't read it as a family loss. It's not family lost and family regain. We have family laws are there. That's called plurality of laws, not the family law. So the framers of the Indian Constitution incorporated very important directive, that is Article 44, which speaks that the state shall make an endeavor to secure uniform civil codes. This is the constitutional mandate. Right from 1947 to 2022, that is today, much water has flown under the bridge. Sincere attempts were made by the states to bring intra-religious uniformity, but not inter-religious uniformity. So there is a difference between intra-religious uniformity and inter-religious uniformity. So that's in the year 1955 to 56 years, we made a sincere attempt to reform the Hindu personal law in the form of Hindu Code Bill or Hindu Code. So that is called intra-religious uniformity. So in the year 1937, that is prior to independence, we made an attempt to bring what we call uniform civil law among Muslims. That is called Shariat Application Act of 1937. Then in the year 2000, an attempt was made to bring uniform divorce law among Christians. So this is what we have done. This is very good to what we can say achievement. There is no doubt in it. But when it comes to interreligious unification of personal law, instead of taking the directive principle into the positive direction, there are occasions where the state has taken Article 44 into reverse direction. This is my observation. So therefore, number of articles that I have written, how the state is taking the Article 44 into reverse direction. There are a number of occasions. So in number of occasions, the Supreme Court also lamentates that the negative attitude of the states towards the uniform civil courts. So instances where we can refer, I need that because you're all studied family law. So right from Shabanu's case, followed by Sharla Madgal, Lily Thomas, John Walmattam, and etc. other cases, the Supreme Court lamented that the state is not taking a positive step towards the uniform civil code. Then the immediate question is, here the very important point where you have to note as a student of personal law or a student of law in this country. When we are talking about the uniform civil code, there are three important areas, three important principles one should be remember. Point number one is, this is a very important, my dear friends, whether Article 44 of the Indian Constitution is mandatory or recommendatory. Point number one. So what is the answer is, the language of Article 44 is a very clear. The state shall make an endeavor, so that to procure, to secure uniform civil code. It is not an optional. It's an option is not given to the state. If not today, tomorrow. If not tomorrow, day after tomorrow. It is the duty of the state to bring the uniform civil code, and it has to make an attempt. Endeavor it should be made. So this is the time to examine whether such an endeavor is made or not. And the second important thing is that as far as the uniform civil code is concerned, the objective of the uniform civil code does not mean that the majority law shall prevail over the minority. So this is if there is any hidden agenda or wrong conception is there to somebody that my law should be imposed on minorities or minority law should be imposed on majorities, that is not the correct. The acid test is that whether whatever the sunny side is there in a particular religion, whether it's a Hindu or a Muslim or a Christian or Parsi or Jew, whatever it may be, whatever the bright side of the family law is there, sunny sides, we have to take it and assimilate it into the uniform civil code. Whether it's a minority law or majority law, it is immaterial, sunny side. And it is nothing but collecting the flowers from different gardens, different places, and preparing a wonderful bouquet. That is what the uniform civil code. Not that the majority law is imposing on minorities. This is a very important caution that we have to take the student of personal law. And the third important facet is that the uniform civil code involves some sentiments, emotions, and what we call feelings. So of both minorities and majorities. So if you make an attempt to bring a uniform civil code, definitely it directly or indirectly affects their what we call emotions and feelings. Then what we have to do is, there should not be any bypassing the legitimate expectations of either minorities or majorities That is what we call an equilibrium should be maintained while we are drafting the Uniform Civil Code. You are preparing the Uniform Civil Code. You are what we can say articulating the Uniform Civil Code and also presenting the Uniform Civil Code in the Assembly. In such a case, what is the suggestion is that wide circulation is necessary. Then we have to what we call take the opinions of the cross sections of the society before preparing the what we can say the Uniform Civil Code. So whatever the apprehensions are there in the minds of the minority, that should be removed by the majority. So these are the three important facets, my dear friends. What is that called? A Uniform Civil Code is a mandatory. It cannot be avoided. And what we call the feelings of the people that we have to take into consideration. And it does not mean that what we call the majority law shall prevail over the minorities. So then coming to the second important aspect is that surrogacy. So in my view, there are a number of reasons for surrogacy. Maybe men and women unable to produce gametes. There may be repeated miscarriages. There may be pelvic disorder, hysterectomy, high blood pressure, and other serious health issues may be there. In such a case, we have to see for the alternatives, either assisted reproductive technology or surrogacy. Whatever the case may be, the childless parents would need love, affection, happiness, and with this, what we call from their offspring, and particularly in discharging certain secular duties or indispensable duties or pious obligations, or to maintain the lineage, or to retain the inheritance, the child is very important. So this was possible by adoption. There's no doubt in it. We can take child into adoption. But the surrogacy is the technology, that is the surrogacy is the most socially complicated and controversial assisted reproductive technology. And it is not a simple arrangement. It is extremely complex. Surrogacy changes the natural motherhood of conception by creating life in the laboratory. My dear friends, surrogacy arrangements have different implications on different societies in view of different culture, social values, religion, or what we can say social setup. So surrogacy is a great blessing to the childless couple. They have the satisfaction of parenthood, happiness, sense of emotional belonging, and they can also, what we can say, or the feeling of mother and fatherhood. Then there are so many complex issues involved in surrogacy or reproductive technology, like medical issues are there, technological issues are there, ethical issues are there, moral issues are there, biological or religious or what we can say legal and human rights issues are there. At the same time, there are other human rights issues and challenges too. They are connected to this, what we can say, surrogacy and assisted reproductive technology, like right to procreation, right to health, right to privacy, right to human dignity, right to know the parenthood, right to retain one's own culture, right to citizenship, right to passport, and right to custody of the child. Some of these legal ramifications, what the student of human rights jurisprudence should always consider while you are dealing with the surrogacy. It is not that just because the act is there, we have recent legislation that we have as far as the surrogacy is concerned. Why I'm focusing is that in the year 2008, I had an opportunity to visit Canada and participate in a world conference. And my paper was socio-legal aspects of surrogacy. So it was immediately after baby Manji Amada's case. So I represented India and presented a paper in Halifax. So there is a world conference. Right from 2008 to 2021, so there are a number of issues, challenges as far as the surrogacy was concerned. Then as a result that we have 2021 legislation that is known as a Surrogacy Regulation Act 2021. So I don't want to make a presentation on 2021. maybe one of your participants in the seminar, she or he would have done it. Just I will read out the important features of 2021, my dear friends. Surrogacy is possible only when there was a medical need, not out of fancy, please understand. And non-commercial, the commercial surrogacy is not permitted. And only for the sale or prostitution for any other medical purposes, surrogacy or assisted reproductive technology will not be permitted. So that is the permission from the competent authority and also order from the judicial magistrate is also required. So then the insurance coverage is required, protection is required to the surrogate mother, and willingness certificate from the surrogate mother is required. No woman shall act as a surrogate mother for her own gametes. So no woman shall act as a surrogate mother for more than once. A certificate from the physician, a certificate from the medical doctor, fitness certificate that she has to procure, they have to procure. So like this, there are so many facts are there, and I don't want to waste your time. So you please go through the Act of 2021 as far as the surrogacy is concerned. Now but here the point is, after the passing of this legislation, the Surrogacy Regulation Act 2021, there were certain challenges. Even the Act was also challenged. So some of the issues were that, and right of unmarried person is not considered in this legislation. So we have to examine, is it right? Whether a right of unmarried person to go to surrogacy is justified, or assisted reproductive, this reproductive technology is justified or not, we have to do it. So this is, I'm leaving to you. So then the right to livelihood is affected. Surrogacy is a livelihood, sorry. And right to commercial surrogacy is also affected. And right of LGBT community is also affected. Right of abortion is also affected. Right to surrogate mothers to retain the child is also affected. These are some of the issues where they are challenging before the Supreme Court. So what I would like to impress upon you is that these issues, my dear students, these issues and challenges and intricacies were already examined before the select committee, before the different committees, while the surrogate bill was circulated from 2008 to 2021, my dear friends. It was not, Rome is not built in a day. Surrogate Act was not made in a day. Right from 2008 to every year, revised the bill, revised the bill, revised the bill. Ultimately in 2021, it was materialized. What I would like to impress upon is that the Parliament has used its wisdom while making this surrogacy law. Because we are in India, so that is we have certain ethos are there, we have the culture, values are there, public policy is there, morality is there, decency is there. So considering all these facets, the surrogacy bill was prepared and the law was made. But still, and it is open to the people to go to the court and also examine whether these what we call the human rights of the person in this country was protected by the Act of 2021 or not. It is up to you. So that you can do it. And now coming to the first point that we already examined about the Uniform Civil Code. The second point is with regard to surrogacy. And the last point is family dispute resolution mechanisms. Family dispute resolution mechanisms. This is also one of my fertile area. And while I'm teaching alternative dispute resolution mechanisms pertaining to family. See, in family disputes involve serious and emotional aspects, sensitive aspects, delicate issues, the children, offspring issues, blood relatives issues, conjugal and privacy issues. That's why my advice is always that whenever there is a family issue is there, please handle with care, handle with care. So that is on every packet, it is written as, please handle with care. Because the what we call the China material, what we call China shop material is available in that. That's glass material or crockery is available. So that is, so please handle with care. So sometimes ego is there, sometimes hate, sometimes violence, sometimes incompatibility, social factors are there, economic factors are there, caste, particularly in this country, the caste factors are there. At the time of marriage, caste was not the very important what we call facet or very important issue. Then after that, caste will come into the family through what we can say back doors. And religious issues are there, denominational issues are there, low income issue, no income issue, higher income issue. All these are all issues pertaining to what we call the family aspects. So like this, sometimes we have the peer groups. So the influence of the peer groups also, the family problems will arise. Influence. So you tell me who is your friend, I'll tell you what you are. So influence of the family members. There is a mother-in-law's concept is there, and father-in-law's concept is there. Mother's theory is there, and what we call mother-in-law's theory is there. They are called different theories, mother's theory and mother-in-law's theory. Psychological factors, physical factors, and sometimes where what we can say male chauvinism, radical feminism. What is that? Male chauvinism, radical feminism. We are all what we call feminists, but we are not radical feminists. We as a feminist is that called who supports the cause of women who needs a special care and protection in this country, or whatever the case may be. So like this, we have certain identified problems are there. But when these issues, they are not legal issues alone, my dear friends. So there are particularly NRI issues, late working hours, shift duties, working different places, emotional issues are there, and what we call overactivism, inactivism. So these are all issues. So in such a case, instead of handling these issues by a regular court, what is required is family litigation needs special procedure, rigid rules of procedure, rigid rules of CPC, rigid rules of CRPC, and evidence. They are not suitable to the family issues. That's why, as a result, what we had in the year 1984, we enacted a wonderful legislation that is known as a Family Courts Act of 1984. So these the very purpose of the Family Courts Act of 1984 was to provide congenial, comfortable, and healthy environment, my dear friends. So underline these words: congenial, comfortable, and healthy environments in resolving the family disputes. So later, it was supported by Section 89 CPC. Is another important dimension the family dispute resolution mechanisms. So we introduced the arbitration in certain cases. We introduced the conciliation in certain cases. We introduced the mediation in certain cases. We introduced the judicial settlement in certain cases. So therefore, Section 89 is made mandatory now, mandatory. So before what we call framing of the issues, or after framing of the issues, it is the duty of the judge of the family court to see that whether there is any alternative to resolve the family disputes or not. It's a mandatory. There also the word shall is used. And the family court judge, the judge of the family court shall make an endeavor, whatever what I said in the uniform civil courts, in the same manner here also he has to make an endeavor to settle the disputes either by conciliation or a mediation, my dear friends. So this is Salem Advocates Bar Association's case. 2005 made it a wonderful what we call observation. So that is similarly followed by Afghan's infrastructure company's case. In all these cases, the Supreme Court made it very clear that's called mediation is necessary and also important in resolving the family disputes. I don't want to take much time, just I want to conclude it. However, the alternative will give good results if the mediator works with a special care and protection. Here is the mediator is playing this important role. The conciliator is playing an important role. So what is required to the mediator is that it is not just a BA, LLM, BA, LLB qualification, or maybe LLM qualification. What is required to the mediator is that honesty, integrity, impartiality, neutrality, bias, unbiased, open-mindedness, logical thinking, confidentiality, transparency, and what we call respect the views of the others, perseverance, patience, and assess the interest of the parties to the case. Please, my dear law students, you see, is there any law qualification here? There is no law qualification. What is required is honesty is required, integrity is required, impartiality is required, and neutrality is required. Of course, law is also an additional qualification. So a person with who is specialized in family law, definitely he will handle the case differently. So therefore, what I would like to impress upon is that ultimately, when we are giving this case to the mediator or to the conciliator, and you should handle that case with the care and caution, and also handle with, and you should make an effort. So finally, I conclude that I have what we call done my time, that is 15 minutes. So that is with these important what we call facets and emerging issues. There are so many emerging issues. The 2130 emerging issues were identified in our brochure, in our flyer. So this is not the right time to speak. So that is when if I come to Kerala, and definitely I'll come to the Kerala Academy. And Nagaraj, Mr. Nagaraj is my good friend. And so I used to come to the Kerala during N.K. Jaykumar's period and Sunny's period. And Bismi, I think Bismi is not at Kerala. She was in Mahatma Gandhi University, I think. I conclude my presentation on the legal fraternity, may look into the legal ramifications of this subject, and particularly uniform civil codes, and secondly, surrogacy and assisted reproductive technology, both the things, and finally, dispute resolution, family dispute resolution mechanism. So with this, I thank the organizers for giving an opportunity. So once again, I thank you. Thank you.
I extend my heartfelt thanks to you, sir, for your admirable words. It's a great honor to have you with us today. Gratitude is the fairest blossom which springs from the soul. Now, let me take this opportunity to welcome Advocate Arya Sunil Pol Ma'am, Assistant Professor, Kerala Law Academy Law College, to deliver the vote of thanks to the valedictory session of 11th International Seminar on Family Laws, Changing Perspectives, Contemporary Challenges and Solutions. Ma'am, please.
Thank you, Anjana. No matter how defeated you think you are, you must always keep working on yourself and move forward. A warm good evening to one and all. Most respected Dr. Bismi Gopalakrishnan Ma'am, Dean, Professor and Head, School of Legal Thought, MG University, Kottayam. Mr. Nikuse Afese Sir, Associate Professor, Havasa University of Law, Ethiopia. Professor Dr. Y.F. Jaykumar Sir, Professor, University College of Law, Osmania University. Advocate Nagaraj Sir, Director, Kerala Law Academy, Bar Member, Bar Council of Kerala. Professor K. Anilkumar Sir, Director, Administration, Students and Faculty Affairs. Professor Harindran K. Sir, Principal, Kerala Law Academy Law College, are the respected personalities present here. And dear students, I consider it is an absolute privilege to present a vote of thanks to the dignitaries of today's valedictory session of 11th International Seminar organized by Kerala Law Academy Law College, Trivandrum. Family law comprises a wide spectrum of rules they are in practice regarding family matters such as marriage, restitution, divorce, inheritance, guardianship, maintenance, etc. There are some legally enforceable rights and duties arise when one legal validation to the status of interpersonal relationship. The justification for having laws that affect the most private aspect of our life is to ensure protection of individual rights and to uphold certain norms to essential to human dignity. This seminar explored the different aspects of family laws as it plays a crucial role in society. The purpose of this seminar is to discuss changing perspectives, contemporary challenges, and solutions regarding family laws. This seminar is also very well discussed the solution to overcome this challenge. I extend my heartfelt gratitude to late Dr.N.Narayanan, founder, Kerala Law Academy, who always remain as an inspiration for us conducting these international seminars. We have been listening to the most informative and fruitful speech delivered by respected Dr. Bismi Gopalakrishnan Ma'am, Dean, MG University. She is always a part of Kerala Law Academy family. She is a strong woman with so intelligent, vibrant, hardworking, and charismatic personality. Ma'am, we highly appreciate your readiness to accept our invitation and indebted to you giving us a part of our valuable time. On behalf of Kerala Law Academy, I propose heartfelt vote of thanks to you, ma'am. I would like to thank this opportunity to thank Mr. Nikusa Afese, Associate Professor, Hawassa University, Ethiopia. He's an international personality providing us with an enlightening speech and giving us a part of precious time. On behalf of Kerala Law Academy, I propose a heartfelt vote of thanks to you, sir. I would also like to take opportunity to thank respected Professor Dr. Y.F. J. Kumar, Professor, Osmania University, for providing us such a fruitful, knowledgeful session. We all found it extremely informative and enlightening. On behalf of Kerala Law Academy, I propose heartfelt vote of thanks to you, sir. With utmost respect, I would extend my vote of thanks to Advocate Dr.N.Narayanan sir, Director, Kerala Law Academy Law College, Advocate High Court of Kerala, Chairman of Kerala Law Academy Moot Court Society, Member Bar Council of Kerala. He always support every activity in college and has encouraged to do our best. We are indebted to you, sir, being a pillar of strength for us, courage. With a deep sense of respect, I thank you, sir, for your hard work and effort. I take this opportunity to thank Professor K. Anil Kumar, sir, Director, Students and Faculty Affairs, Kerala Law Academy Law College. Sir is an efficient administrator, inspirator, and constant motivator to all faculties and students and everyone in around KLA. Thank you so much, sir. Professor Harindran K. sir, our principal, is always a source of inspiration to all academic activities in this college. On behalf of Kerala Law Academy, I propose a sincere thanks to Harindran sir. I express my heartfelt thanks to our senior faculties, Professor G. Anil Kumar sir, Professor Achida Nair ma'am, and my co-conveners, Dr. Dekshna Saraswati ma'am, General Secretary, Moot Court Society, Assistant Professor, Kerala Law Academy Law College, Srimati Vidya Vivi, Assistant Professor, Kerala Law Academy Law College, Sri Varun Teves, for all this your hard work and effort for making this seminar possible. Thank you all. I express my special thanks to all the resource person and participant for this seminar. So worthful of knowledge, we have been fortunate to this seminar. Thank you. We have been fortunate to enough backed by a team of proactive, dedicated students of KLA who are well versed in the duties of conveners, moderators, and participants. My sincere thanks to you students. And my sincere thanks to the student conveners in this seminar, Gautam Vishram, G.S. Gogul, Lakshmi V.S., Anchita Unnitan, Devika, Ashwin Rajiv, Aneka, Gauri H., Nandakishore, Namita, for their tireless effort in making this seminar its epitome. I mean, short words to involvement and their willingness to take completion of this task beyond their comfort zone. Thank you all, dear students. May I conclude by extending my sincere thanks to all faculties who are presenting to make this seminar a grand success. I would like to express my profound gratitude to the Honorable Resource Person to take out the busy schedule to enlighten these sessions to great success. Thank you. Finally, I would like to express my special thanks to our IT team who has provided us technical support, which is significant due to this virtual event. Now, I conclude by extending my sincere thanks to all participants, parents, students, teachers, non-teaching staff, and all those who are present here to make the seminar a grand success. Thank you all.
I extend a heartfelt thanks to you, ma'am, for your efforts and contributions to make this seminar a grand, successful one. This seminar was really inspiring, visionary, and kindled to shape our knowledge. I honestly believe this seminar was very fruitful and a successful one, as it solicits us to understand more profoundly about various insights in the spheres of family law.
And nothing would be possible without the wholehearted support and guidance of some strong-willed, determined people behind the curtain. You all together made this seminar a grand success and an informative one.
Now, I would like to thank from the bottom of my heart our respected dignitaries for your presence, which indeed made this an auspicious one. Last but not least, I thank each one of you present here for your kind cooperation. This is Namita Babu Benedict,
and Anjana Raj signing off. Thank you
Thank
all.
you all.